Okay, all right. All right, good morning. The meeting on the Commission on State Mandates will come to order. Welcome to our hybrid meeting. Senate Bill 544 amended the Bagley-Keene Open Meeting Act to allow hybrid meetings under Government Code Section 11123.2. Closer? Okay, a little closer. All right, better? All right. 11123.2, where access to this meeting is provided both remotely and at a physical teleconference location. The commission continues its commitment to ensure that its public meetings are accessible to the public and that the public has the opportunity to observe the meeting and to participate by providing written and verbal comment on commission matters. For those participating in person, I have some housekeeping information. On the table near the wall are paper copies of the meeting notice and agenda, new filings, witness list, and consent calendar. The electronic public hearing binder is also located there on an iPad. When called up for an item, the parties and witnesses will please sit at the witness tables. The restrooms are located out the door and down the hall to the left. The men's room is across the open atrium. The code for both restrooms is posted on the door as you exit the conference room. Finally, please take note of the emergency exits in the room. For those participating remotely, the materials for today's meeting, including the notice, agenda, and witness list, are all available on the Commission's website at www.csm.ca.gov under the Hearings tab. When called for an item, the parties and witnesses will please turn on your video and unmute your microphone. At the conclusion of your item, please turn off your video and mute your microphone. In the event we experience technical difficulties or the meeting is bumped offline, we will restart and allow time for people to rejoin before recommencing the meeting. Juliana, will you please call the roll?
First, please join me in welcoming our new Commission Chairperson, Ms. Michelle Perrault. Ms. Perrault is the Chief Deputy Director of Policy for the Department of Finance. Prior to this, Ms. Perrault was the Deputy Director of Legislation. Before joining the Department of Finance, she was the Executive Director of Communications for the Roseville City School District. Prior to that, she was the Director of the Administrative Services Division of the California Commission on Teacher Credentialing. She served as the Advocacy and Communications Director for California State University Chancellor's Office. She was the Communications Grassroots Director for the California Rehabilitation Association and the Media Relations Director for the California Chamber of Commerce. Welcome, Michelle. Second, please join me in welcoming our new Commission Vice Chairperson, William Polland, General Counsel at the Treasurer's Office. Welcome, William. Finally, join me in welcoming our new Commission Designee from the Controller's Office, Deborah Gallegos, Deputy Controller of Investments and Financial Management. Welcome, Deborah. And now I will call the roll. Mr. Adams.
Here.
Ms. Gallegos. Ms. Holman.
Here.
Ms. Nash.
Here.
Mr. Polland.
Here.
Ms. Perrault.
Here. Okay, we'll now move on to item 1. Are there any objections to or additional corrections of the January 26, 2024 minutes?
I would move approval.
Okay. Is there any public comment on this item? Seeing none. Any further discussion?
Madam Chair, I'm Joe Ortiz from the Commission on State Mandates, and I'm
Yes.
currently monitoring public comments from our virtual attendees, and there are no public comments to report at this time.
Thank you so much. All right, I have a motion by Mr. Adams, I believe. Is there a second? All right, a second by Ms. Holman. Thank you. I will get that. Roll call, please.
Mr. Adams.
Aye.
Ms. Gallegos. Ms. Holman.
Aye.
Ms. Nash.
Aye.
Mr. Polland.
Abstain.
Ms. Perrault.
Aye. Okay, that motion is carried. We will now move on to public comments for matters that are not on the agenda.
Please note that the Commission may not take action on items that are not on the agenda. However, it may schedule issues raised by the public for consideration at future meetings. We invite the public to comment on matters that are on the agenda as they are taken up.
Do we have any public comments?
I see none in the room, Madam Chair.
Thank you. Online?
Madam Chair, no public comments.
Okay. At this time, I do have something to add. In honor of departing Department of Finance designee Gail Miller, I would like to thank her for her outstanding service to the state of California and especially her work for this commission as chairperson since 2019. Would any members, other members like to add any additional comments? All right, seeing none, we will move to the next item, consent calendar. Juliana?
Next is the proposed consent calendar. Items 6 and 7 are proposed for consent.
All right. Are there any objections, excuse me, to the proposed consent calendar from the members or from members of the public? Seeing none in the room?
Madam Chair, I
No
move-
public comments online.
Is there a motion to adopt?
I would so move.
All right, it's been moved. Is there a second?
Second.
Okay, moved in second. We can have a roll call, please.
Mr. Adams.
Aye.
Ms. Gallegos.
Aye.
Ms. Holman.
Aye.
Ms. Nash.
Aye.
Mr. Polland.
Aye.
Ms. Peralt.
Aye. Okay, that motion carries. So we will move to swearing in.
Will the parties and witnesses for items 3 and 4 participating remotely, please turn on your video and unmute your microphone? And will all parties please rise and state your name for the record?
David Burhan and guest, representative of claimants and agenda item 3.
Donna Furby, Department of Finance.
Jennifer Fordyce, State Water Board. Catherine, I think you're on mute.
My apologies. Catherine Hagan with the Office of Chief Counsel, the State Water Resources Control Board. Thank you.
Mr. Packowitz. Do you solemnly swear or affirm that the testimony which you are about to give is true and correct based on your personal knowledge, information, or belief?
I do.
I do.
Thank you. Please be seated. Item 2 is reserved for appeals of the executive director decisions. There are no appeals to consider for this hearing. Next is item 3. Senior Commission Counsel Elizabeth McGinnis will please present a proposed decision on California Regional Water Quality Control Board, Santa Ana Region, order number R8 2010-0033 10 TC07. At this time, we invite the parties and witnesses for item 3 participating remotely. Please turn on your video and unmute your microphone.
Good morning. Can you hear me okay? This test claim alleges reimbursable costs mandated by the state to comply with the 2010 test claim permit issued by the Santa Ana Regional Water Quality Control Board, which requires the development and implementation of a local implementation plan template and jurisdiction-specific local implementation plans, the development and implementation of ordinances to control known pathogen or bacteria indicator sources, the one-time review and revision of the illicit discharges and illegal connections program to include a proactive illicit discharge detection and elimination program using specified guidance, requires the County of Riverside to create and maintain a database of new septic systems approved since 2008, increases the scope of certain commercial facilities inspections and requires an annual evaluation of the residential facilities program, imposes new requirements for regulating stormwater discharges from new development and significant redevelopment projects, requires the development and implementation of a watershed action plan, requires formal training for permittee staff responsible for the review and approval of project-specific water quality management plans, and requires the development of a proposal for assessing the effectiveness of the urban runoff management program that uses specific criteria and guidance. Staff finds that many alleged activities in the test claim are not new, but were required by the prior permit. Staff further finds that the requirements regarding municipal new development or redevelopment projects are not mandated by the state and are not unique to government, and therefore do not mandate a new program or higher level of service. Staff recommends that the commission partially approve the test claim for the new mandated requirements identified in the proposed decision, addressing the following: local implementation plans, the proactive illicit discharge detection and elimination program, the septic system database, the watershed action plan, employee training, and urban runoff management program effectiveness assessment, all from January 29th, 2010 through December 31st, 2017 only. Beginning January 1st, 2018, the claimants have fee authority sufficient as a matter of law to cover the costs of the program within the meaning of Government Code Section 17556D, and thus there are no costs mandated by the state on or after this date. In addition, consistent with two recent Court of Appeal decisions, the claimants have the authority to impose regulatory fees for all new mandated activities relating to new development and significant redevelopment projects and the inspection of commercial properties, which are sufficient as a matter of law to cover the costs, and thus there are no costs mandated by the state for these activities under Government Code Section 17556D. Finally, staff finds that there is no evidence in the record that the Riverside County Flood and Water Conservation District was forced to spend its own proceeds of taxes and therefore does not have any costs mandated by the state. Staff therefore recommends that the commission adopt the proposed decision to partially approve the test claim and authorize staff to make any technical or non-substantive changes to the decision following the hearing. Thank you.
Thank you. Parties and witnesses, please state your names for the record. Mr. Burhan, for the claimants, would you like to begin?
Yes, please. David Burhan, Burhan and Guest in Los Angeles. I am claim representative for the Riverside County Flood Control and Water Conservation District, the County of Riverside, and the cities of Beaumont, Corona, Hemet, Lake Elsinore, Moreno Valley, Paris, and San Jacinto.
Thank you, Mr. Burhan. Ms. Farabee, for the Department of Finance, do you have any comments?
Yes, thank you. The Department of Finance previously filed written comments on the test claim, and we have no additional comments to offer today. Thank you.
Thank you.
Excuse me,
Yes.
Madam Chair. We do have comments. I thought you were just having council identify themselves. So if you want me to proceed with those, I'd be happy to do so.
Please go ahead and proceed with comments.
Thank you very much. I first want to thank Chair Miller for her service to the commission and welcome the new chair and vice chair. Sorry for these long test claims, but it's nature of the beast. I also want to thank staff for their considerable work in promulgating the draft and final proposed decisions. And it's a lot of work. We do appreciate it. I want to today incorporate all of our previous comment and correspondence on this test claim. My comments at today's hearing also do not represent any waiver of those previous comments. We appreciate that the final proposed decision, which I'll call the FPD, was modified from the draft to award claimants reimbursement for some additional test claim permit elements. Claimants believe that some additional permit requirements, which have been identified in our comments and which I will briefly touch on today, are also unfunded mandates. And the first are those LIP, local implementation plan requirements in section 7. When I use 7, I'm meaning Roman 7, so I'll try to make that clear. The FPD determined that various requirements relating to LIPs did constitute unfunded state mandates. However, it also concluded that one section of the permit, section Roman 7D3, which required that permittees implement the applicable LIPs that were adopted in response to continued exceedances of water quality standards, was not new. We disagree respectfully. The LIP provisions in the test claim permit clearly are new, as reflected by the FPD's treatment of those provisions. For the first time in the test claim permit, each permittee was required to develop such implementation plans. How then can a provision directing permittees to implement those new provisions also not be new? While the FPD draws parallels with similar provisions in the preceding 2002 permit, requiring implementation of revised BMPs and other requirements. By the way, BMPs, for the new people on the board, on the commission rather, are best management practices, basically things you do to improve water quality. They concluded that because that provision was in the previous permit, simply including LIPs in this requirement is not new. We disagree. At minimum, including LIPs represents a higher level of service required of permittees in the test claim permit. Even though the mechanism for implementing those requirements may be similar to that in the previous permit, the obligations being implemented, the LIP themselves, are new. Thus, the requirements of Section 73 are in fact a new and/or higher level of service and are thus reimbursable. I'd next like to discuss the ICID and IDDE provisions in Section 9 and Appendix 3. And again, more acronyms, but I think Council has explained that. While the FPD agrees that Section 9D and the provisions of Section 9H and Appendix 3, Section 3E3 are unfunded mandates, the FPD also concludes that the requirements of Section 9E are not. Section 9E requires permittees to enhance their existing ICID programs by incorporating proactive IDDE practices that are laid out in guidance documents. Sections 9D and 9E work together to require this incorporation. This is a clear example of a provision which requires permittees to upgrade existing programs which constitute a new program and/or higher level of service. While the FPD concludes that Section D's requirements are new, it also concludes that Section 9E, which requires incorporation of those principles in a series of ICID tasks, is not. The FPD contends that because these ICID tasks were performed under the 2002 permit, then Section 9E is not new. Thus, if there was a public education component of the ICID program, incorporating IDDE principles into that component is not new because ICID public education was done under the previous permit. With respect, we believe that the FPD has gotten it backwards. The Water Board itself, in the fact sheet and in a test claim permit finding, indicated that permittees were required to revise their ICID programs, those existing programs, to incorporate IDDE concepts. The Water Board admitted in comments the test claim permit required permittees to develop, quote, a more proactive IDDE program to increase effective control of illicit discharges. That is the intent of Section 9E as its plain language states. It is to require permittees to incorporate IDDE concepts into 5 identified elements of their ICID programs. It is not to perform those programs themselves, which may be but are not necessarily pre-existing, but to review and revise those existing programs as necessary to incorporate the new IDDE principles. And even if the ICID tasks themselves were the focus of this provision, as the FPD contends, Section 9E still requires a higher level of service by permittees due to the need to incorporate the IDDE concepts. Section 9E required real effort by permittees, as the exhibits to the declaration of Rohini Mustafa in our comments demonstrate. It is not the case where claimants were simply spending more money, as the FPD asserts. The section required permittees to perform and pay for new activities required by the new requirements of the permit, which is the definition of what constitutes a new program, or at minimum, a higher level service. With regard to section 9H, which was granted in part in the FPD, the FPD would deny reimbursement for costs associated with maintaining a database of ICID incidents that led to enforcement on the ground that this was in the previous permit. However, the test claim permit went farther by requiring each permittee to maintain a base and to create a new database covering additional incidents. I would note that the report of waste discharge, which was issued by the permittees in 2014, which is in the record, stated that the overwhelming majority of these ICID incidents, in fact, did not lead to enforcement, which I would add is a good thing, because it shows that informal enforcement is being effective in that region. I would next like to discuss commercial and residential inspection requirements of section 11. The FPD concludes that the requirements of test claim section permit section 11E6, which is to evaluate residential programs and to report on that evaluation in their annual reports, is not new, because federal regulations and the prior permit included elements of control measures directed at residential activities. We respectfully disagree. The approach followed in the FPD of looking to the context of these requirements rather than the plain permit language is, we submit, in error. The permit in section 11E1 and the fact sheet states that permittees were to develop and implement a residential program. Moreover, the requirements of sections 11E2 through 11E5 do not constitute the entirety of what that residential program is, but set minimum standards. The commission must assume that the Water Board meant what it adopted. Had the permit merely required permittees to continue to do the work required under the prior permit, the residential program either would be absent, or the permit would state that permittees should continue to carry out residential elements. This is not the case. I draw your attention to some language in the FPD on page 204, where it states, quote, "The commission must therefore presume that the regional board intended every word, phrase, and provision in the test claim permit to have meaning and to perform a useful function. The Water Board intended the requirements in section 11E6 to perform a function, and the commission should treat that requirement as a new mandate." My last comment on the permit itself, and I apologize for the flickering lights, is on section 12, development requirements. The FPD concludes that requirements at issue in section 12 are not reimbursable state mandates. First, it concludes that certain development requirements are not reimbursable because if they are related to a municipal project, that project was triggered by a decision of the municipality and not a mandate of the state. However, that analysis, we believe, ignores the requirements of the provisions at issue. For example, section 12C1 requires permits to review their general plan and other planning documents to eliminate barriers to low impact development, or hydrological constituents of concern, HCOC, policies, and to report on that review. This work is required of permittees whether or not they construct any significant development or redevelopment projects. The same is true for section 12E4, which requires permittees to revise their ordinances, codes, and building standards to promote green infrastructure and LID techniques. Neither of these efforts are connected with any BMP requirements that would apply to any specific municipal, or for that matter, private development projects, but they must be performed. A similar analysis applies to sections 12E1, 12E3, 12F1 and 2, and 12G1. Second, the FPD errs in concluding that sections 12A5, C1, D1, E1 through 4, E9, and G1 are not requirements unique to government or which provide peculiarly governmental service. The FPD appears to mix the implementation of these requirements with their promulgation. Yes, both municipal and private development projects are subject to Section 12 BMP requirements, but the promulgation of those requirements themselves is strictly the responsibilities of the permittees. This is true, but looking at the plain language of these sections, which refer in every case to requirements that are imposed on a permittee or permittees. And the regulation of development is a core municipal activity, one unique to government. In addition, these requirements provide a peculiarly governmental service by regulating development and providing a service to the public through promotion of clean water. The citation of the County of Los Angeles case is an opposite. There, the county was found not to have an unfunded mandates claim for having to comply with state elevator regulations that applied to both public and private operators. Here, the analogy would be for the state to require the county itself to devise those regulations. Finally, the requirements to issue the test claim regarding Section 12 are not subject to the Mitigation Fee Act because those requirements relate to general development requirements, not project-specific exactions. Finally, I'd like to briefly discuss some of the cost recovery issues. Our comments set forth in some detail why SB 231, which restricts our recovery to the period ending December 31st, 2017, should not be relied on by the commission. I won't repeat that here. However, I do want to address some other of the conclusions. We disagree with the FPD regarding our ability to raise regulatory fees for Section 12D7. This is one that we were given in the final proposed decision. That provision requires permittees to develop an enforcement strategy for mobile businesses. A strategy is not connected with any benefit to mobile benefit businesses, even in the aggregate. It is preparatory to the actual implementation of the strategy, which we agree potentially could be recovered by costs. Similarly, Section 12C1, which I mentioned above, requires permittees to revise ordinances and building standards to promote green infrastructure, but there is no link to any development project. And such requirements are not incidental to any such development project. So there is no way to raise regulatory fees to pay for that effort. This is not the same as where permittees were required to develop model BMPs for subsequent development projects, which was the case in the San Diego permit case that was cited in the FPD. The work required here is to remove barriers to LID and HCOC requirements, which, like the Newhall Water case that was cited, benefit all residents. And in fact, neither provision here refers to development projects at all. Like the watershed action plan requirements discussed in the FPD, these requirements and others noted in our comments are not linked to any actual or even projected development project. They are a step before the kind of requirements that the court in the San Diego permit case found to be recoverable from regulatory fees. Our comments set forth why the costs of these requirements and others are at issue in Section 12 cannot be recovered through regulatory fees. I want to thank you for your attention to these matters. I would be happy to answer any questions that commission members may have.
Thank you, Mr. Brand. Before I move on, let me back up and please have the remaining parties and witnesses state your name for the record.
This is Catherine Hagan with the State Water Resources Control Board.
Jennifer Fordyce, State Water Resources Control Board.
Thank you so much. All righty. So Ms. Hagan and Ms. Fordyce for the State Water Resources Control Board and the Santa Ana Regional Water Quality Control Board, do you have any comments?
It's us. Good morning, commission members and staff. We just have very brief comments. We wanted to note that we appreciate and recognize the very thorough and exhaustive work by the commission staff in developing this draft proposed decision that you're considering today. We agree with a significant number of the recommendations in that final decision. We do continue to disagree with some aspects of the proposed decision, but we've already expressed these concerns in prior written comments in this matter, so we'll not be reiterating those here today. With that, we appreciate the opportunity to speak and are available to answer any questions you may have.
Thank you. Are there any questions from the board?
Yes, I do have some questions, if I may. In particular for FPD council. First, just a level setting question. When you refer to FPD, I'm assuming that's flood protection district. Is that accurate?
He's talking about the final proposed decision.
Okay. Okay. All right. Then second question, when you're challenging these determinations in the proposed decision, are you doing so on behalf of each one of your clients, or is there any particularization?
Because the permit does differentiate somewhat with regard to certain provisions. For example, some of the development provisions, I believe, are not applicable to the flood control district, which does not have land use authority. That would only be on behalf of our claimants who are municipalities. But I'm speaking today on behalf of all claimants, as I am their claim representative. And another example would be County of Riverside alone has the database requirement.
Right, thank you. Then also a question about your final argument. Essentially, it sounded to me like you were saying the flood protection district did not have the ability to capitalize certain expenses that look like general type overhead expenses into its regulatory fee structure. Therefore, that resulted in a new or additional expense that you're seeking recovery for. Is that the crux of your argument, or is there nuance I'm missing?
I think so. Yeah, I mean, what we are saying, again, what the final proposed decision states is that based on some recent California law, costs associated with, for example, providing template BMPs for people who are doing development projects, you know, a new shopping center, a new firehouse, whatever, even though those costs were incurred by the permittees, they can be recovered from the development proponent, at least the private one. And what we are saying is that the requirements, some of the requirements that were identified in the FPD as being subject to recovery from regulatory fees are in fact not, because they are not related to any particular development project, nor do they serve any particular development project. They are instead basically what I would call deck clearing requirements to make sure that the plans, the ordinances, etc., of a particular municipality are promote basic green development initiatives.
Okay, so that sounds to me like a requirement that's generally applicable across everybody within the jurisdiction and not, you know, particularized to a specific applicant. Therefore, you're not able to charge that applicant for those costs. Is that a summary of your argument?
Yes, sir.
Then are there other general type overhead costs, though, that the protection district incurs that it likewise doesn't capitalize into its regulatory fees, costs of copier, costs of desk, these other general overhead type costs? How do those get recovered then by the district?
Again, I want to just be careful. There is no such thing as a flood protection district.
Okay, I'm using the wrong term. Sorry.
Yeah, I mean, let's just call them claimants. I think it would probably be easier for at least
Okay,
for me to understand the question.
But this is just one specific claimant though, because the argument with this one claimant is it can raise its fees and therefore isn't subject to any recovery, whereas the other basket of claimants seem to be able to, per the proposed decision, recover costs for certain items incurred between two dates.
I don't think that's exactly what the proposed decision is what the proposed decision is saying is that the flood control district, because it has a benefit assessment, is not using proceeds of taxes to perform these permit functions and thus is not entitled to reimbursement. However, the requirements in section 12 and throughout the permit that are at issue here are incurred by each of the claimants, which are the county and those several cities.
And if I may, just to add some clarification, the proposed decision separately addresses the flood control district and finds that because it did not use its own proceeds of taxes, there's no further analysis. They're not a potential claimant here. They have not incurred any fees. So the analysis that you're performing or speaking to really goes to the county and the cities within the county. So, and then in regards to the issue of promulgation versus implementation, the analysis for implementation of these new development requirements was analyzed as they apply to municipal development projects, and then separately as they apply to private development projects. And then there's another tier to it, which is the actual promulgation, that would apply to both, and the implementation, the promulgation is an activity that's performed in a regulatory capacity, but the implementation would be the municipal developer itself, what duties are imposed on it, what it has to do then as a developer in that capacity. So there's sort of three aspects to that analysis, which are separately analyzed in the decision.
And just to dovetail, all of those costs that relate to the municipal developer are recommended for denial on the ground that they are not mandated by the state. They're decisions that are made at the local level, and there's no state direction for those. The activities that are required relating to the private developers, adoption of the regulations, the planning activities, as they relate to private development, all have regulatory fee authority and are recommended for denial based on 17556D.
If I may just respond briefly to Ms. Sheldon, and I also, council, I think, has accurately described the analysis and the decision. It is our contention that the municipal private distinction does not hold water when the requirements, again, are unrelated to the decision to build a project. The decision and the position of the commission has been that if a city, for example, decides to build a new firehouse, that firehouse is a discretionary act by the city and is not mandated by the state. I should say that the water pollution control elements of that project, we don't agree with that, but we understand that to be the position. What we are saying is that the requirements that are not related to that particular decision to build the firehouse, that is to review one's ordinances, general plans, etc., should not be subject to that municipal discretionary act exception.
No further questions. Thank you.
Other questions? Is there any public comment on this item?
I see no public comment, Madam Chair.
Thank you. Online?
No public comment, Madam Chair.
Okay, is there any further discussion? Okay, is there a motion?
Okay, I'll move to adopt the proposed decision.
Okay, moved by Mr. Mullen, second by Ms. Gallegos. I knew I was going to say that wrong. I'm so sorry. Would you please call the roll?
Mr. Adams.
Aye.
Ms. Gallegos.
Aye.
Ms. Holman.
Aye.
Ms. Nash.
Aye.
Mr. Polland.
Aye.
Ms. Peralt.
Aye. That motion carries.
We now ask the presenters participating remotely for item 3 to please turn off their video and mute their microphones. Next is item 4. Senior Commission Counsel Eric Feller will please turn on your video and microphone and present a proposed decision on public school restrooms, menstrual products, 22 TC 04. At this time, we invite the parties and witnesses for item 4 participating remotely to please turn on your video and unmute your microphone, and those participating in person, please come to the table.
All right, good morning. This test claim is based on the Menstrual Equity for All Act of 2021 that requires public schools that maintain any combination of classes from grades 6 to 12 to stock all women's restrooms, any all gender restrooms, and at least one men's restroom with an adequate supply of menstrual products at all times, free of charge for pupils on or before the start of the 2022-23 school year. The test claim statute also requires these schools to post a notice regarding the statutory requirements in a prominent and conspicuous location in every restroom required to stock menstrual products. The notice must include the text of the statutory section and contact information for the person who maintains the supply of the products. Under prior law, only certain Title I schools in grades 6 to 12 were required to stock 50% of their restrooms with menstrual products, and the commission determined this was a reimbursable state mandate in May 2019. The requirement to stock all women's restrooms, all gender restrooms, and at least one men's restroom mandates a higher level of service for these Title I schools and a new program for the remaining non-Title I schools. And the notice requirement is new for all schools. So staff finds the test claim statute imposes a reimbursable state mandated program beginning January 1, 2022, and recommends the commission adopt the proposed decision to approve this test claim and authorize staff to make any technical and substantive changes following the hearing.
Madam Chair, if I may,
Yes,
I'd like to verify that Ms. Dickerson and Mr. Ferguson have been sworn in.
no, I
Okay.
don't believe so.
Then, would you please rise? Do you solemnly swear or affirm that the testimony which you are about to give is true and correct based on your personal knowledge, information, or belief? I do.
I do.
Thank you.
Thank you. At this time, if parties and witnesses would please state your names for the record, and we'll start with those in the room. Push the button, it'll turn green.
Good morning, Art Palkowitz on behalf of the claimant, Hesperia Unified School District.
Dr. George Landon, Deputy Superintendent with the Hesperia Unified School District.
And we'll move online.
Martina Dickerson with the Department of Finance.
Chris Ferguson with the Department of Finance.
Thank you. Mr. Palkowitz and Dr. Landon, for the claimants, would you like to begin?
Yes, thank you very much. We would like to thank staff for their thorough analysis. As Mr. Fuller correctly stated, there was a prior law that was applicable to only 40% of schools based on their poverty level. That was approved by this commission. 7-0, and Mr. Adams was one of the individuals at that commission hearing. This new law extends this requirement to provide sanitary products to all schools. And as Mr. Fuller correctly stated, it also goes to providing to at least one men's restroom at a facility. It was the intent of this bill to extend the gender to others than just the females. As a result, in the statute, the test claim statute that we provided, it states that this is to provide access to menstrual products is a basic human right, vital for ensuring health, dignity, and full participation of all Californians in public life. The legislature identifies gender equity for women, men's, transgender, or gender non-conforming people who may also menstruate, decreasing emotional distress, physical infection, disease, and basic education equity, preventing or reducing absenteeism and significant performance gaps. This intent by the legislature is clear that this is meant to be a new program for the public, a high level of service. And we agree with the staff's recommendation. And myself and Dr. Landon are here to answer any questions you might have. Thank you.
Any further comments, Dr. Lynn? Okay. Ms. Dickerson and Mr. Ferguson for the Department of Finance, do you have any comments?
No, we don't have any comments beyond what we've already submitted via letters.
Thank you. Is there any public comment on this item?
No comment in the room, Madam Chair.
I
No
don't have a
public comment online.
Go ahead.
I have a comment. Thank you. So obviously we agree with the draft final decision. In the decision, pages 20 through 24 summarize the finance comments. We submitted objections to these comments when they were filed based on it's not confirming with specific code of regulations that require certification. As someone who appears before the commission for years, I would like to know how this is handled. Should it remain in this draft analysis based on that non-conforming, or is this still going to be allowed in this future comments? Thank you.
I'd like to address that. Thank you. First of all, the comments that were raised were issues of fact that were more appropriately, will be more appropriately addressed during the parameters and guidelines phase. The issue here is a pure question of law. We always summarize party positions. They will continue to always be summarized in these test claim decisions. So they will be as stated, but our analysis is a question of law and we apply the law. And so as we indicated, we did not address those comments. They're more appropriately addressed during parameters and guidelines, where you do have different standards of review that are applicable to particular costs. Yes.
Thank you.
Okay. See no further public comments. Are there any comments from the commission?
Madam Chair, I would move approval of the proposed decision.
All right, moved by Mr. Adams. Do I have a second?
Also,
Okay, I think I heard Ms. Nash. Was that correct?
Yeah.
First, okay, as a second, if I could get a roll call, please.
Mr. Adams.
Aye.
Ms. Gallegos.
Aye.
Ms. Holman.
Aye.
Ms. Nash.
Aye.
Mr. Polland.
Aye.
Ms. Peralt.
Aye. All right, the motion carries.
We now ask the presenters participating remotely for item 4 to please turn off their video and mute their microphones. And those participating in person, please return to your seats. Item 5 is reserved for county applications for a finding of significant financial distress, or SB 1033 applications. No SB 1033 applications have been filed. Next, Program Analyst Jill McGee will please turn on her video and microphone and present item 8, the legislative update.
Good morning. The following are the legislative updates since the last time the commission met. First, AB 1781, state mandates, claims. This substantive spot bill would change the minimum mandate reimbursement claim amount from $1,000 to $800. On January 3rd, 2024, this bill was read for the first time, and on January 16th, 2024, it was referred to the Assembly Committee on Local Government. Staff will continue to monitor legislation for bills that impact the mandates process. Thank you.
Thank you, Jill. Next, Chief Legal Counsel Camille Shelton will please present item 9, the Chief Legal Counsel report.
Good morning. Just one thing to report during this open session report. Yesterday, the LA County Superior Court did hear the demurs filed by the Commission on State Mandates in the Department of Finance. The court granted both demurs and the case is dismissed. Thank you.
Item 10 is the Executive Director Report. Assistant Executive Director Dennis Supachano will please turn on his video and unmute his microphone for his introduction to the Commission. It's my pleasure to introduce Dennis Supachana, our Assistant Executive Director. Dennis earned his BA in Government from Sacramento State. He is coming to us from the Department of Transportation, Division of Construction, where he was acting branch chief since September 2023, supervising a team of 6 working on labor compliance matters and working with internal and external stakeholders on DBE and DVBE compliance. Prior to that, he was an AGPA, working on labor compliance modules and analysis of labor law legislation. Before the Department of Finance, before the Department of Transportation, Dennis was an AGPA for the Secretary of State, where he acted as CalRIM team leader for various projects, including the development of records management training for state agencies, providing guidance to state agencies, reviewing records retention schedules from state agencies, and analyzing legislation and procedures that affected records management. Prior to state service, Dennis was a political finance analyst for a private law firm. Dennis started with the Commission on February 20.
Thank you, and it's a pleasure to be working with the Commission.
Welcome to the Commission, Dennis. Please turn off your video and mute your microphone.
Okay.
And now back to my report. I have 3 information items. The Commission's 2024-2025 budget. The Budget Act of 2024 was introduced on January 10, which includes the Commission's operating budget of $3.399 million. This is a decrease of $116,000 from last budget after adjustments for salaries and benefits. The Governor's budget also includes $129.997 million for local assistance for local agency mandated programs. This is a decrease of $39.51 million. The specific programs and their funding are listed in my Executive Director's report. The Commission's budget will be heard in Assembly Budget Subcommittee 5 on April 9. Workload. After this hearing, there are 37 pending test claims, 34 of which are regarding stormwater NPDES permits. There is 1 parameters and guidelines regarding stormwater with lengthy comment periods pursuant to a stipulation of the parties. There are 4 statewide cost estimates and 1 IRC pending. Commission staff expects to complete all currently pending test claims and IRCs by approximately September 2026 Commission hearing, depending on staffing and other workload. However, some of the test claims may be heard and decided earlier than currently indicated if they are consolidated for hearing. Finally, tentative agenda items. Please check the tentative agenda items on my Executive Director's report to see if an item you are interested in is coming up. You can also use the pending caseload documents on the Commission's website, which are updated at least bi-monthly to see when something is tentatively set for hearing. Please expect to receive draft proposed decisions on all test claim and IRC matters for review and comment at least 8 weeks prior to the hearing date and a proposed decision approximately 2 weeks before the hearing. Finally, a reminder to please notify Commission staff not later than the Wednesday prior to a hearing that you or a witness that you are bringing plan to testify. Please include the names of the people who will be speaking for inclusion on the witness list, and also include email addresses for remote participants to receive their panelist links. Madam Chair, that concludes my report.
Thank you. At this time, the Commission will meet in closed executive session pursuant to Government Code Section 11126E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. The commission will also confer on personnel matters pursuant to Government Code Section 11126A1, and we will reconvene in open session in approximately 15 minutes. Okay. The commission met in closed executive session pursuant to Government Code Section 11126E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. The commission also conferred on personnel matters pursuant to Government Code Section 11126A1. With no further business to discuss, I'll entertain a motion to adjourn. Moved by Ms. Gallegos. Second by Ms. Holman. And motion, we have to roll call.
Mr. Adams.
Aye.
Ms. Gallegos.
Aye.
Ms. Holman. Aye. Ms. Nash.
Aye.
Mr. Polland.
Aye.
Ms. Peralt.
Aye. All right, motion carries and the meeting is adjourned.